Now that we're having a look at criminal liability, what would criminal liability entail? What does it speak about? What are we mentioning when we talk about criminal liability? Anyone? What comes to mind when we see criminal liability or hear the term? Go ahead. Okay, so Aisha put in the comment. Alright, so in chat, Actus, Reus, and mens rea. Okay. So those are the only two main things I would think about. The Actus, Reus, and the mens rea. Okay, I guess that's what we're thinking about when it comes to criminal liability. So let's speak about the whole host of what criminal liability actually is, right? So what we're looking at, right, is criminal law in and of itself, and it is one of the concepts that regulates behavior, right, in society, right, especially considerably detrimental behavior within society. These are the laws that protect generally the right to life, right? Or the right to the protection of property, etc. Right? These are laws put in place to protect these important rights, right? So criminal law serves several purposes, including death deterrence, rehabilitation, retribution, and protection of society. And these are some of the sentencing series that we will discuss. All right. So we're looking at the Actus Reus, most definitely, right? So we know that the Actus Reus speaks to the guilty act, right? It speaks to, right, some amount of voluntary action, either the action of the accused, the omission, right, of an action by the accused, or the state of affairs being brought about by any type of breach of laws rather, right, or the actions of the accused, right? So for a defendant to be found guilty, there must be a demonstrable actus reus that constitutes a criminal offense. Alright? And I'm seeing again in the chat where Miss Spence says that criminal liability refers to how one can be found guilty or not guilty of a crime. Okay? That's essentially what it is, to be very truthful. So we're looking at the actus reus here, right? The act specifically. And the mens rea, right, would speak to the guilty mind, right? So it speaks to the knowledge of wrongdoing or intent that a person, the accused, would have, right? Or in some cases would not have, right? So it speaks to the intent or knowledge of wrongdoing. It signifies that the defendant had a certain state of mind such as intent, recklessness, or negligence when coming to the actus reus or when committing the actus reus, right? So the actus reus is literally what is done or what is not done that brought about a state of affairs that breaches the law, while the mens rea speaks to whether or not there's knowledge of the breach, right, of the law, right, or intent to commit the actus reus, right? So that is what the actus reus and the mens rea speaks about. Are there any issues there? Support center, just let me know if there are any issues. Everything there is fine? Yes, again, I'm not sure if it's too early to receive responses. Okay, so the thumbs up can works. I'll be able to see them. So if I ask if everything is good and everything is good, they can just use the thumbs up reaction, right? And if there's any question at all, feel free to just jump in immediately. Just raise your hand. I can hear the notification, and you can just go ahead and ask the question or input something. Okay, so that's the actus reus and the mens rea. Now we're looking at the term actus non facit reum nisi mens rea. What does this speak to? Actus non facit reum nisi mens rea. Anyone? What does this term speak to? Has anyone seen this before? Heard about it, spoke about it? No? Alright. So Actus non facit reum nisi mensit rea speaks to the general overlying principle of criminal law. Right? So it basically speaks, right, to the fact that it speaks to a fact that a crime is not committed, right, if the actus reus and the mens rea do not coincide, right, as Mr. puts in the chat, right. So there must be the coincidence, right, of an actus reus and a mens rea for a crime to be constituted, right. So looking at the causation of forbidden states of affairs, the defendant, right, cause a particular state of affairs that is prohibited by criminal law, right? This means that there must be a direct link between the defendant's actions, the actus reus, and the criminal outcome. For instance, if the crime is theft, the prosecution must prove that the defendant unlawfully took someone's property, right? Someone else's property, right? That's what we're looking at, the actus reus. And the defined state of mind now, at the time of causing the forbidden state of affairs, the defendant had a specific state of mind regarding the act. It involves showing that the defendant had the necessary mens rea, such as intent to commit the crime, knowledge of their actions, knowledge that the actions were wrong, or reckless disregard for the consequences of their actions. For example, in a murder case, the prosecution must prove that the defendant had the intention to kill or cause grievous bodily harm. So we're looking at that. So we must have a defined mens rea and a defined actus reus, and they must coincide for it to constitute a crime, right? For predominantly majority of criminal law, we're going to be looking at strict liability and why we don't care about the mens rea per se when it comes to strict liability. Go ahead.
So, sir, what if there's no mens rea brought out in the situation, but they did the act?
But they did
What
the act. Okay, so if there's
without? Yes,
without intent,
yes.
okay, so if they did the act without intent, right? There are many. If it depends on the act itself, right? It depends on the severity of the act, because if the severity of the act is that, okay, let's say that their act creates a state of affairs that causes someone to die, but it was proven that they had no mens rea, then that would be a defense, right? There will be some amount of defense via automatism, insanity, diminished responsibility, these different defenses that will reduce their charge of murder to manslaughter. So there would be a reduction if mens rea isn't met. Or if it was strict liability now, strict liability speaks to the fact that we don't essentially care about whether or not you intended to do it, but the crime was committed and you're going to feel the full extent of the law. That's with strict liability. But we're going to speak about strict liability versus the other instances where we do not have the mens rea, right? And what occurs in those instances, right? But usually for more severe instances with the lack of mens rea, there are still offenses and punishments that are given, right? There are still punishments, right? In some cases now where it is not as severe and you didn't have the mens rea, then you would be fine, right? I'm going to be speaking about those things. So proving beyond a reasonable doubt, this is another principle of criminal law, right? The standard of proof in criminal cases is beyond a reasonable doubt. This means that the evidence provided by the prosecution, right, must be convincing enough to the court. It must please the court to the extent that there is no reasonable doubt left in the mind of a reasonable person that the defendant is guilty of the crime charged. Meaning that the prosecution, right, must prove, right, without any hesitation, right, that the person has committed the crime. If the prosecution provides evidence that the crime was done by the defendant, right, and there are major issues and holes within the evidence, right, that leads to reasonable doubt, then that is not proof enough for the crime, right? So looking at stuff like that, the prosecution must provide convincing evidence, right, that allows us to believe without any type of doubt that that crime was done, right? So we're looking at those type of things, right? So we can't use hearsay. We can't use I thought that. We can't use that I heard that. No. We must provide evidence that would definitively prove, right, that the defendant has committed the crime. That is what the prosecution must look at, right? So as we go into the legal field, criminal law actually helps to delineate who would want to, take up the role of the defense versus the prosecution. I most definitely would be a prosecutor, right? That is something that I do thoroughly enjoy, right? Looking at proving with beyond a reasonable doubt, right? So we'll be looking at those stuff. So the case law that speaks to the mens rea and the actus reus specifically, it brings us to the cases of R.V. Della 1952, where there's no actus and where there's actus reus but no mens rea. What occurred in this case? Anyone? R.V. Della 1952. What occurred here? I'm waiting for somebody to unmute and just tell me the facts of the case, and then we speak about the decision and the ratio decidendi. So, waiting.
Sir, I'm not really sure about this case, but does it have something to do with like a car?
Wait, hold on. Okay, give me a second. I think there's an issue here. One moment, please. Because now, as I go over the case in my head, I think I need to fix one thing about it here. Because the case itself, actually, there was, in this case, there was mens rea. Yeah, so there in this case, actually, I wrote it incorrectly on the slide. I'm gonna reshare it. There was mens rea, but no actus reus. Right? Um. Yeah. So there was a mens rea, but no
So,
actus
sir,
reus.
therefore he wouldn't be guilty because there was no act to the mind to what he or I don't know.
Mm, I get what you're saying. Let me reshare to make this palpable here. Hopefully, we can see the screen again. We're able to see the screen again. Okay, let me know when you can see it. Okay, so looking at here now. So mens rea but no actus reus. Let me check the chat because I saw something posted in chat. So there was mens rea because okay. So the entire thing of the case, right? So the defendant was charged with the offense of what was it? Obtaining money by um false pretenses, right? So Deller, right? Deller's knowledge, right? To Deller's knowledge, it was not what we're looking at here, right? Is some encumbrances, right? He sold his car, right, to the complainant, right, representing that it was free from any encumbrances. To Deller's knowledge, it was not free from encumbrances, right? So we're looking at that. So he's trying to sell his car and try to obtain more money fraudulently, right? So we're looking at that. And that was under the Bills of Sales Act specifically. The actus reus of the offense was the existence of um, a valid encumbrance, such as the bill of sale, right, on the title of the car. However, Deller did not realize that the bill of sale was null and void, as the lender did not register it. So this means that what Deller was trying to do, right, was lie to the complainant, right? Presenting any type of false representation about the encumbrances on the car, right? He thought they were encumbrances and he was trying to tell the complainant that there were no encumbrances, right? But in actuality, there were actually no encumbrances, right? So he thought he was lying, but actually the encumbrances were not registered. Therefore, he intended, right, to sell the car, right, under false pretenses, right? But in actuality, he did sell the car, right, in good faith. So there was mens rea, but no actus reus. He intended to obtain money through fraudulent pretenses, but he actually thought, right, that he was doing that, but not necessarily actually did sell the car, right, which was not under false pretenses by the Bills of Sales Act, right? So he had the mens rea, right? He wanted to defraud the person by selling the car with encumbrances, but what he actually did was sell the car without encumbrances. Therefore, there was no actus reus, right? Therefore, we look at the term actus non facit nisi mensit rea. There was no coincidence of actus reus and mens rea, right? So actus reus was not there for the crime. As it relates to RV Dice, know what occurred in this case. So Dyson inflicted injuries on a child twice. Okay, so we're looking at that from Miss Thomas in the chat. The child died later on and he was charged with manslaughter, although the conviction was squashed because there was no actus reus of the crime. Okay, let's be more specific, right? It was November of 1906. And I remember this case now because this case was the most interesting case, along with RV Tandy and RV Most, right? These are some cases that can never forget, right? So it was in November of 1906, right? That the child was beaten and sustained injuries. And it was also in December of 1907 that he also sustained injuries, right? So all of these injuries that the child would have sustained, right? The child would have died by the 5th of March in 1908, right? So all of these injuries, right? He's what we're looking at now, right? The parents continually beat the child, right? Dyson continually beat the child until the child succumbed to the injuries, right? And he was actually indicted for manslaughter and not murder. What happened? He had no actus reus, and this was because, right, the time delineation for the crime has passed. So the child's death has occurred, right, longer than 1 year and 1 day. So it occurred in a time longer than required for law, right? So we're looking at the fact that because if it would have been a murder, right, but because of the time limitations and constraints on the law that are actually now overruled, right, he actually did not commit the actus reus for murder but for manslaughter. Go ahead.
So, sir, I was saying, this, I think a question like this about the year and a day rule thing came on a um paper one question. But like, sir, isn't it weird? Because imagine the if imagine yeah, imagine Dyson beat the child, sir, and because of the year and a day rule, he didn't get charged for murder. Sir, sometimes the law just weird, because he literally beat the child to, you know,
To death.
like come on.
Yeah.
Sometimes it just weird.
It is very weird. I think this has been overruled. There was a legal reform of 1960 something, I think. Right? There was a legal reform that changed that rule, right? But because this was done before the reform, then this it would have helped. All right. Somebody raise their hand. I heard somebody raise their hand a while ago. I'm not sure if they want to speak. Okay, I'm not sure. But all right, so let's continue. The elements of actus reus, right? So we know that there are specific essential elements for determining actus reus, right? And what were these elements? What are these elements? List them. Anyone? What are the elements of actus reus? You want me to start you off? Acts are one of the elements.
Sir, omissions,
Omissions, lovely. Consequences.
state of affairs.
And okay, lovely. So those are all of them: acts, omissions, consequences, and the what we call the surrounding circumstances or the state of affairs. Those are the four main elements of the Actus Reus. So we're starting with acts, right? So by the definition, an act refers to the voluntary bodily movement that leads to the to a prohibited result, right? So looking at that, so we're talking about the fact that the person must be aware and must be moving voluntarily in conscious movement their own muscles, right? You must be in conscious control of your body and move your own muscles to commit an act. Does that make sense? You must commit an act voluntary, right? In conscious movement or via conscious movement, right? There are defenses to this. The defense of automatism. And we know that automatism speaks or implies, right, to specific events in which the defendant claims that they have lost control of their physical actions and that the act that they committed was not of their own. We have internal or non-insane automatism, and we have insane or what we call external automatism. For the non-insane automatism, it refers to involuntary action caused by external factors, right? So looking at that, and it's where the defendant is not suffering from any mental illness or defect, but some external factor affected them, right? And insane would have been, right, caused by some type of disease of the mind, right, or some type of internal deficiency, right, leading to involuntary actions. And this overlaps with the defense of insanity. But when we talk about defenses now, we're gonna speak about how insanity, diminished responsibility, and automatism are separate, right? So looking at automatism, when we talk about defenses and when we look at defenses, I won't speak about automatism because we're going to speak about it right now and we're speaking about it right now. Right? So let's have a look at this now. The case law, the locus classicus for insane automatism, Bratty versus the Attorney General of Northern Ireland, 1963. Can somebody provide the facts of the case? Bratty v. the Attorney General of Northern Ireland, 1963. Someone give me the case. Does anyone know the case? No. Okay, so Shan doesn't
Sir,
know the case. Okay, go ahead.
sir, was it a case about like the person was convicted of murder for an 18-year-old girl, and like the automatism come in at some sort of epilepsy something.
Mm-hmm.
Yeah.
So that's
So
the
I'm not
thing
really
with.
know how to explain myself, but I think you get what me I say.
But could you write it though?
In some way,
In some way. Okay, so generally, right, the defendant, what he did, right? He took off a girl's stocking and strangled her with it, right? I think she was an 18-year-old. She was young, right? So he took off the girl's stocking and strangled her with it, and told the police that he saw some sort of blackness taking over his vision, some darkness, right? Some darkness came over him. Something came over him, and he did not know what he was doing, right? He didn't realize anything. That's what he told, right? The authorities, right? But in his case, there was a medical condition providing medical evidence for what he was suffering from. That was psychomotor epilepsy, right? So it might have prevented him from knowing the nature, right, and the quality of his actions, right? He was charged with murder and pleaded defense of automatism and insanity, right? But the jury rejected them and convicted him. So basically, the act was so gruesome, the jury rejected everything and just told him that he was supposed to be convicted. You're supposed to go to prison, right? But there was an appeal, right? his condition was evidence for the defense of insanity specifically, right? Insanity would work, but not automatism, right? And we're looking at what Lord Denning was saying. Lord Denning would have indicated that the defense of automatism has very narrow limits as a defense, right? So it's very, very difficult to get the defense of automatism to work, right? So it's generally confined to acts done while you are unconscious or due to any type of spasms or reflex actions or any type of convulsions, right, that are involuntary, right? So looking at that, the main thing that got Bratty off was well, that defended Bratty would have been insanity, right? And he was committed to a mental asylum later. So looking at that, in his insane automatism, that defense that he was trying to put was not going to work for this case. And it's a very interesting case because it is in this case that Lord Denning stated out the narrow limits of insane automatism. Right? Now, the dictum from Bratty was used as persuasive precedent in R.V. Burgess 1991. What happened in R.V. Burgess 1991? In 1991. Go ahead.
So, in this case, like Burgess, like he was charged with wounding, with like GBH, right?
Mm-hmm.
And then basically his defense was that he was sleepwalking and suffering from non-insane automatism, but like there was medical evidence available, and the only defense that was available was insanity, but he was found not guilty by reason of insanity, something like that.
On insanity? Not necessarily insanity, you know. Right? Okay, so let's discuss this. So it's not necessarily insanity, you know, because this was actually one of the only cases where automatism actually worked. Right? Insanity could have worked, it would have worked, right? But in this case, automatism could have succeeded. And we're gonna explain why it could have succeeded. Because in the Burgess case, right, what happened was he was suffering from an attack of an illness, right? And due to that attack, it caused him to actually wound somebody else, right? But he did so involuntarily, and there was evidence because he suffered from apoplexy, which was a type of disease or illness which caused involuntary spasms. So what he did, he spasmed and wounded the person, right? It was a involuntary convulsion of his body, right? And this was insane automatism, right? Insane automatism could work, right? So the accused action was completely involuntary and had benefit to the defense of automatism, right? So we could look at that. So RV Burgess, right? In that case, insane automatism worked, right? Looking at that, or internal automatism rather, right? So looking at those type of things. No, in this case it would be non-insane. My bad, right? Because I'm saying insane, but non-insane automatism, right? So that speaks to the fact that it was an internal issue, right? The apoplexy, the disease. My bad, right? For insane automatism, no. Externally, we have Hill v. Baxter, 1958. What happened in Hill v. Baxter?
Sir,
So,
Oh, well, I want Kineisha to try. Go ahead.
okay, so the defendant drove a motor vehicle across the road junction at a fast speed, ignoring its illumination
Mm-hmm.
signs, and then he collided with a motor car. Yeah.
Mm-hmm.
Then the motor, no, then the van then continued from like a short distance, and he overturned. He went to the hospital, and the defendant said that he could not remember what took place. Something like that.
Okay, so he couldn't remember what took place generally, right? So that was the thing, right? And he actually caused the death, right, of some persons by reckless driving, right? But actually, after a while, we found out, right, that he was actually stung by a swarm of bees while he was driving. Yes, it is the bee's case. So he was stung by a swarm of bees while driving that caused those events, right? So you see the state of affairs that caused the crime, right? It was not of his doing. Remember that the acts on the Actus Reus states that you have to voluntarily do it. It was not of his doing, and because it was external, this would have been insane automatism, insane automatism, external automatism that helped in Hill v. Baxter. For non-insane automatism, we have the failure, right, via the Monotony rules in RV Hennessy, right, and then we have some success in RV Quick and Pemberton. But what happened in RV Hennessy? Let me just state this before anybody goes and discuss Hennessy, right? As it relates to module 1 and module 2, you can get away by understanding the concepts for criminal law. You must have cases, right? Because that's like the majority of criminal law is cases. All the definitions for these things are found in the locus classici, all in the cases, right? So cases are important for criminal law. Go ahead, RV Hennessy.
Sir,
Go ahead.
so in this case, sir, um, so sir, basically, um, he was diabetic, right?
Mm-hmm.
And he was driving a stolen car, but like he was having a diabetic episode and he did not take his insulin for like a couple of days,
Mm-hmm.
and yeah, at that remember, and then some about hyper where them like that
Hyperglycemia.
that word, sir, I don't remember honestly.
Okay, you sound like you're giving up, but you're actually giving the facts for the case, alright? So looking at a disqualified driver, right? And he didn't take the insulin, right? Because I think he was stressed and was suffering from anxiety and depression and all of these different things. He didn't take the insulin, right? So at the time, right, that the act was being committed, he was suffering from hyperglycemia, right? And was in a state of automatism, right? But the judge found that his defense was insanity within the Monotony rules, right? So looking at that, so the accused was convicted and appealed on the ground that the judge was wrong in the and his depression and the marital troubles, because marital troubles was one of the reasons for his depression, right? Were important factors that overrode his diabetes, right? His appeal was completely dismissed, right? And what happened here? We relied on the cases such as Hill v. Baxter and R.V. Sullivan. And we know that R.V. Sullivan is an insanity case, but we're going to talk about it when we reach insanity, right? But what was happening here, right, is that even though he was in a state of automatism, right, the reason why it failed is because of his depression. His depression and anxiety was the reason why he did not take the pills, right, the insulin rather, right, and that's what caused the entire state of automatism, right. So his other factors such as depression and marital troubles would have overrode or overpowered his diabetes, right? Not that it overpowered his diabetes within him, right? But it was more important to the case than diabetes, right? He should have argued insanity more so than automatism. Remember that what Lord Denning stated, right, in Bratty v. the Attorney General of Northern Ireland, right, that automatism is a very narrow defense, right? So looking at that, but this event succeeded in RV Quick and Pemberton, and can anybody give me the facts of the case? RV Quick and Pemberton. Anyone knows that case?
Sir, was this about, sir, I'm not sure, but was this a case about like the person was diabetic and they suffered from hypo, so this one is hypoglycemia but the other one was hyper, so
Okay. What was
sir,
happening here?
sir, is it that one?
Well, I'm looking at hyperglycemia here, but was it hypo? I'll have to check the facts there. But you could continue. It is about that a patient. You want to get any further?
So, sir, basically, the person didn't take their insulin in the morning, and they didn't eat too much during the day, and like I think they took in alcohol, so it
Yes,
like
they drank
somewhat
alcohol.
affected them.
Mm.
So basically they had an episode that they blacked out and attacked the victim, um, who suffered from like fractured nose and bruising and all of that.
Mm.
And then the person, what you call them, the defendant, them he later like passed out and deny say like he him never remember what him do.
Okay, I think that's a viable case, no, but I'm not sure whether or not it is RV Quick and Pemberton. Right, I'm wondering whether or not it's RV Quick and Pemberton, because in this case, right, there were two psychiatric nurses, right, that were accused of assaulting the patient, right? Because the patient was unaware, did not take the insulin, never ate a small amount of breakfast, right? They drank with throughout the day and had no lunch, right? So they were having a glycemic episode and was unaware of the sexual acts that they were going to engage in, right? So what we're looking at now, right? The judge would have rejected the defense of automatism in this case, holding that it was insanity, right? That was supposed to be the actual approach, right? And he was convicted, right? As was Pemberton and Isabetta, right? So we're looking at those issues there. Both appeal against the conviction were successful. What are we looking at here, right? Quick alleged mental condition, if ever existed, was not caused for his diabetes, but by his use of insulin prescribed by his doctor, right? Such um malfunctioning of the mind, right, as there was caused by an external factor and not by bodily disorder. So what we're looking at here now, we're looking at the fact that he had taken the insulin, right? So he took the insulin, didn't have a large breakfast, drank alcohol, no lunch, everything like that, right? What occurred here was completely a state of unaware of acts in which they were unaware, right? But this was also most definitely caused by the fact, right, of taking the insulin. Right? I'm not sure what case specifically. Right, that Saskia was mentioning, right? So it sounds like a case that could be used. But what was happening here was generally as I discussed, right? So what we're looking at here, it kind of failed here, right, as it relates to insane, well, non-insane automatism, right? But non-insane could have worked. So non-insane could have succeeded, but overall, right, we're looking at the fact that this generally would have failed, right? So looking at that, what I should have put here is defense of insanity succeeded, right? Yet again, this is one of the cases where I went through the facts and everything, and was compiling this at 3 a.m. in the morning. So I'll correct anything that seems out of place on the PowerPoint, right? But omissions, no, omission is the next set of issues, right? Or the next set of the next element rather of the Actus Reus. And could anybody explain omissions? How is omission a part of the Actus Reus?
When you have a duty to act but you fail to do so.
Right? So your duty to act, but you don't do it. For example, let's say there's a security guard, right? Or there's a security guard guarding a parking lot or something, right? And and what he's supposed to basically be doing, not a parking lot, guarding a house, right? And what he's supposed to do, is alert the authorities and defend the property. But he see two men coming, and he just runs away, right? He actually omits from his duty, right? He doesn't do it, and that could have created a state of affairs where these two men could have gone in and burgled, lol, committed burglary or something, right? So we're looking at the fact that there is an omission, right, or there is a lack of or delineation from your duty that could create a state of affairs that could result in a crime, right? So the omissions are that the failure to perform an act. Liability upon from a mission occurs when there is a legal duty to act and the defendant fails to fulfill that duty. And there are many ways in which we can get crimes arising from these things, right? So let's look at the first, right? Statutory duty. A statutory duty is a legal obligation imposed on individuals individuals or entities by legislation, right? So they're told to perform specific actions and failure to comply, right, would result in legal consequences. So we're looking at statutory duty. That is one of the first forms of omission if you will actually fail from doing your duty as pronounced by statute, right? Now, the case that I have here is a breach of duty to act by R.V. Crocker. Alright? This is the case I have here. Does anybody know R.V. Crocker? It's a Canadian case though, you know. Alright, I think it's a Canadian case. Right? So what we're looking at, you know, right? Crocker would have been an owner, right? A bar owner, right? And that this was specifically at I think it was a skiing rink. Right? We're looking at that area, right? So he was a bar he owned the bar right at a ski hill, right? So the thing is, no, it's alcohol, right? In this case, under Canadian law, generally under equity as well, right? You see the racer. There was a racer that came up to him, right? I think the racer was Mr. Wood, right? Mr. Stefan Wood, right? He was a racer, right? Before his race, he actually went up to order liquor and stuff like that, right? Knowing that the person would have been participating in a dangerous activity or dangerous sport, right? And this person is a person who is there at the bar, you know, right? At the entire complex. So he would have known that some activities would have been taking place, right? Sports related or requiring good coordination, right? At the time. So the person comes, orders the liquor, but Crocker should have actually denied him, right, the use of the liquor specifically, right, as it relates to the statute in Canadian law, right? But he continued to serve him the drinks, right? Continued to serve him a lot of drinks, got him intoxicated, and then Stephen would have actually gone on to participate, right? And actually, what he would have done now, right, is actually, what did he do now? In this case, he would have actually, despite any type of warnings, right, he would have suffered severe injuries while going down the hill, right? So he participated in the event, right, while intoxicated, succumbed to to multiple injuries, right? And here, Crocker was actually charged for criminal negligence, right? Because of his knowledge, right, that Crocker, because of Crocker's knowledge, right, that Mister would have been participating in these events and competing in these events, he should have, right, stopped Mr. Wood, right, or not sold the alcohol to Mr. Wood. But he did it anyways, right, resulting in the injuries that Mr. Wood would have eventually succumb to, right? So this would have been a breach of statutory duty. Right? It's just a case that I generally used, right, to look at the breach of duty, right? So looking at something like that. Another thing could have been selling alcohol to children as well, right? You're supposed to actually not do that, right? But some persons do. R versus Ditham. Let me see. Is that the actual name of the case? What occurred in that case again?
Sir, that is the case with the police officer witnessing a man getting beat up outside of a bar.
Okay, so that can work, right? So R versus diet witness. So it's a police officer has a specific, contractual duty, right? So that was a general issue. No, there was a brawl outside of the bar, right? Seeing this entire brawl, the policeman actually omitted from actually, stepping in and parting the fight, right? So what we're looking at there is a breach of contractual duty as well. So that should be fine. Okay. As it relates to not contractual duty, statutory duty. But contractual duty now, what we're looking at is, let's say that you are in a position, right? An individual or entity has agreed to perform some amount of task due to the contract, right? Has gained some type of contractual obligation. Now, failing to actually do carry on with this contractual obligation may lead to a state of affairs that brought about a crime, and this will lead to criminal liability. What happened here now? The case that I use is RV Pitwood 1902. Can anybody tell me the case, the specifics of the case, RV Pitwood?
Sir, so it was about the railway crossing.
Mm-hmm.
So the person who was supposed to open the gate, they closed the gate before the train came, and a vehicle passed through the open gate and attempt to cross the line. Yeah.
Okay. So there was a collision, right? And that was due to Pitwood's negligence, right? And that resulted in what was he charged for? Let me just ask, what was he charged for? Suwana stated the chat as well.
Manslaughter.
Well, no one is necessarily charged with manslaughter for the most part. They're usually charged with murder, and then their defense gives manslaughter. But in this case, right, it would have been murder, right? And then, once you look at the case now and it is argued and you see that it was just a breach of contractual duty and he didn't intend for this to happen, but his negligence caused it to happen, then it would have been negligence manslaughter. Right? So looking at that. Duty arising from the virtue of holding an office or professional responsibility. We're looking at the fact that whether that if you have a specific role or a specific professional role or hold a specific office, you have a legal and ethical obligations legal and ethical obligations that may arise from these positions. So you have a position that often includes different responsibilities, right? So usually we see these, right, in patients, clients, stakeholders, those type of things. And failure to actually fulfill these duties will result in some amount of civil and criminal liability. Right? So R versus Adomarco is the case that I normally use, 1995. Can somebody tell me what occurred here in R v Adomarco?
Excuse me, sir. The case of contractual duty was R versus Pitwood.
Yeah, put Pitwood. RV Pitwood 902. Two T's. So for professional responsibility, right, or virtue of holding a public office, we have virtue of holding a office, right? An office or a professional responsibility. We have RV Adomarco. What happened in RV Adomarco? Anyone?
Sir, so basically he was doing an eye operation.
An eye operation?
Isn't it that?
Okay, an eye operation could have been done. Okay, sure, go ahead.
And right, and during the operation, sir, a crucial tube became disconnected, and the patient suffered from a fatal cardiac arrest, and he was convicted of manslaughter
Mm-hmm.
by the breach of duty. Yeah, that's,
Okay, but what was Adomarco's position there? He was an anesthesiologist, right?
yes, sir.
An anesthesis technically, right? So he failed to perform a proper procedure within the surgery, right? During the surgery, right? So he did not even notice the presence of the disconnected endotracheal tube. So even though the alarm went off after the disconnection, which should have alerted him. So you're telling me that you are an anesthetist, right? You are there, right, doing your job in the surgery. You didn't notice that the endotracheal tube was disconnected. The alarm went off and you still didn't notice. Right? That what that occurred, right? So such recklessness on the part of Adam Marco, right, for ignoring the alarm and failing to discover the tube led to the death of his patient, right? And that amounted to a crime of negligence manslaughter. Right? So it is generally murder and manslaughter, though, right? So you kill the patient because of that. And then it's because of the negligence would be negligence manslaughter. Alright? So we have that there. Duty arising from undertaking the care of another, right? So if you actually take it upon yourself to take care of someone, to undertake the care of another, usually an elderly person, right? That refers to the legal and moral obligation that that you will assume. And you must agree to take responsibility, for you are the one that assumed taking the care of the other person. So this duty can be formal or informal and involves providing necessary care and preventing the harm. So failure to do this may result in criminal liability. I have Stone v. Dobbins in 1997. What occurred in this case?
So, sir, they were unmarried couple.
Mm-hmm.
Stone's middle-aged sister came to live with him, and she was incapable of looking after herself. And they decided to wash her and provide her with food.
Mm-hmm.
I don't remember after that, but yeah.
Okay. All right. So let's see what Suana is saying about it as well. So living with her brother and his wife. She suffered from an illness. That illness was anorexia nervosa, right? Resulted in her not being able to take care of herself, right? So she was not able to take care of herself. She was completely incapable of taking care of herself. She refused to see doctor, right? So even though they said that they would have brought doctors, right? She refused to see the doctor or even leave the room that she was in, right? Defendant was the defendant, right? Well, the first defendant, Stone, was actually nearly blind and was seen as not being very bright, right? Not being she wasn't a very bright person. And Davidson was described as an ineffectual and as an ineffectual and inadequate, right? So you're looking at the fact here, right? There was some effort actually made to trying to trace her doctor, and by washing her and feeding her. So they did do something, right? But she subsequently died. The couple was convicted for manslaughter and appealed. What happened in the appeal? Or we're looking at now. Why? What would the appeal fail? Would the appeal succeed? Tell me why. Did it succeed and why? Did it fail and why? Anyone can tell me? No? Okay. So here no, the appeal actually would have failed, right? For the most part there. They would have dismissed the appeal. Because there was actually a duty, right, arising from undertaking the care of another, right? You took it upon yourself to take in the person. You took it upon yourself to house them, to feed them, to bathe them, even though you did make necessary arrangements to get a doctor, right? They were still under your care. The doctor was not there, right? You failed to contact the doctor or to make contact with the doctor, right? And the person is under your care. So anything that happens to the person would be you would be responsible for it, right? So there would be some criminal liability there, and the appeal would not have been taken up, right? They would have been dismissed. Okay. Duty arising from virtue of relationship. So we're looking at here. So we're looking at the legal and moral obligations imposed on the individual due to relationship with another person. The duty requires them to act to prevent harm and provide necessary care and support, right? This is usually in areas of loco parentis, right? And what occurred here now in RV Gibbons and Proctor, 1980. Anyone? R.V. Gibbons and Proctor. Do you know what local parenting speaks about, right? Local parenting speaks to having a duty to take care of a child. Meaning that if if your parent is there, right? Let's say that you are not at the age of 18 or you're not an adult yet, right? Your parents have a local parentis over you. So, if due to their negligence something were to happen to you, your parents can be criminally liable. So they have local parentis. Now, what we're looking at in R versus Gibbons and Proctor, right? Gibbons and Proctor, right, which would be the father and his girlfriend, right, neglected to feed their child, the child, right, the father's child, right. So the father was paying all the attention with his girlfriend and everything like that, and didn't even remember to feed his child, right. As a result, the child slowly died of starvation, right, and they were rightly convicted and guilty of murder, right. So yes, some persons could argue that it's not supposed to manslaughter them get nope, the jury said murder. Um so murder. You're convicted of murder here. So you have a duty by virtue of a relationship usually most likely speaking about in the circumstances of local parentis, right? He had local parentis over the child and refused to feed the child until the child died of starvation. Alright? He went to work, left the child home. Alright, so looking at that, the girlfriend didn't feed the child. Okay, lovely. Go ahead. There is
Sir, didn't Proctor also abuse her or no?
abuse the child.
Yeah.
Mm, there was some. Well, I mean, the negligence would have amounted to abuse. Yes. So that is some. Okay, so that usually happened, right? So what we're looking at the fact is that when the father went to work, etc., right, the child wasn't being fed by the girlfriend, right? And this would have continued to occur because majority of the facts, the facts that we have for these cases are summaries that are interpreted loosely by different sources, right? But the actual facts of the case, all of these things would have happened, right? Usually the father would have gone to work, right? Left, whether or not he left food, right, wasn't being fed. The child wasn't being fed, right? The girlfriend wouldn't have fed the child as well, right? But the fact is that the child most definitely, right? In most cases, children don't die after not being fed for one day, right? So even if the father had returned, right, there would still be the child wouldn't have gotten food, right? Over a period of time, the child died of starvation, right? So we're looking at the fact that they're criminally liable because they had local parentis in this situation, all right? For the duty to minimize one's acts, we're looking at the fact now that even if your act didn't cause something, right? Well, if your act caused something, right? And you had the power to minimize the damage or minimize all of the risks that could stem from your act, you do have a duty to minimize it, right? To reduce the amount or mitigate the harmful consequences of your actions, right? So the duty is applies especially when a person's actions create a dangerous situation or a potential cause of harm, right? Failure to mitigate these issues, right, could result in litigation, right? So what happened here in RV Miller? The arson case, lovely. Miller fell asleep with a cigarette in his hand, right? When he woke up, the bed was caught afire, and all he did was go to another room. So he woke up to a smoldering mattress, right? And he just moved to an adjoining room and went back to sleep. He was found guilty of arson, right? So when he woke up, right then and there, he had a duty to try to hold the mattress, go for water or something, try to stop the fire, but he didn't. So he breached his duty to minimize his own act. Go ahead.
Sir, but how could he like see the mattress tip on fire and don't try to something? I just literally go. I not understand him.
I don't know, I have no idea as it relates to that. It's a weird case. There are other similarly weird cases in criminal law. It's a case like that. So that did occur. Even though it sounds generally weird, it did occur. I mean, some people can't be bothered. Imagine a burning mattress waking me up. Me, I not go back to sleep. Right, so look at that. So RV Miller, right there. So we could look at consequences now. For consequences now, we're looking at right. We're referring to the results that may occur right for a crime to be completed. Right. So some crimes require that specific outcomes or consequences are resulting. Right. So we're looking at these consequences that may occur. All right. Go ahead. So omissions are done, right? Those were the omissions. Now we're looking at consequences as a fact, right? So the consequence of the prosecution must actually establish, right, that the consequence of your actions amounted to some crime, right? So the consequences of one's own actions refers to the outcomes, effects, or results that arise from the individual's choices and behaviors. These consequences can be both positive or negative and impact the individual or others in the surrounding environment. So understanding this responsibility of one's actions and their consequences is a fundamental aspect, right, of personal accountability and ethical conduct, right? So this is really, really important, and it can amount to some amount of illegalities, right? What we generally use is R versus Shipuri, 1987. What occurred in R versus Shipuri? Transporting illegal substances, lovely. Alright, so looking at that. So we know that the defendant was convicted with the offense of attempting to be knowingly involved in dealing with a prohibited drug, right? So he was actually arrested by officials with possessing that drug in the suitcase, right? So he knew, he said that he knew that he was carrying a prohibited drug, but it turned out he was completely tricked, and the substance was not a prohibited drug, but a type of tobacco. His defense that he could his defense was he could not be guilty of the offense, right? As the substance was not a prohibited drug, right? But looking at it now, right? He thought he was carrying a prohibited drug, right? But his drug what that he was carrying was actually not necessarily permitted, right? So it was not illegal. But the thing is that attempting to bring about an illegal consequence was actually an offense. Right, and we're going to look at inchoate offenses. It was a part of inchoate offenses, right? They're attempting to traffic the drug, right? So looking at that, so that was a part of understanding, right? The attempt specifically, right? Under the part of the Actus Reus. So the Actus Reus technically was not given here, right? Was not met perfectly, but he was guilty of a criminal offense, right? By looking at the fact that he attempted. So attempting is a part of an inchoate crime, right? And the actus reus for attempting was actually committed. Okay? What if a third party is injured now? What happens when another person, right, is a threat, right, is causing a threat to another person, and the consequences allows for a crime to evolve, right? We're looking at Paget v. Pemberton, well, RV Paget and Pemberton. What occurred in this case? So okay, so we're looking at the case, right? So Paget kidnapped his pregnant girlfriend, right, and brought her to his house. The police showed up and stepped out of the house, and he stepped out of the house using his girlfriend as a human shield. Okay, when the police was shooting, all right, that's what Swanna says, and Tasha says that the shootout between a man and police, right, where the man used the pregnant woman as a shield, right, with the police shot. The man was guilty for manslaughter, and his appeal was that the police's intervening action, which led to the woman's death, was not upheld. Okay, so we'll look at that now, right? While armed with a shotgun, right, the police would have fired, right, at the accused who held a pregnant girl hostage using her as a human shield, right? The So the police actually would have fired back, right? Accidentally killing the girl. So the accused was charged with the girl's manslaughter and was convicted, and he appealed, right, on the ground that there was novus actus interveniens, right, and not his actions that resulted in the girl's death, and he was actually rightly convicted because his consequences, right, his actions brought the girl in the line of fire and caused her to die, right. So there was no rightful novus actus interveniens, right, that was prohibiting this. Okay, so we have that there. We remember what novus actus interveniens is, right? Hopefully we remember that, right? Intervening acts, lovely. Right, so new intervening acts, right? So let's look at the state of affairs, the last aspect of the Actus Reus, right? The surrounding circumstances. So the circumstances that amount from mere actions could actually create a certain type of state of affair that results in a crime. So certain crimes are defined by the specific situational context, or the conditions being present at the time of the act. So these circumstances must exist for the act to be considered a criminal offense. We're looking at R versus Larsenair and Windsor versus the Chief Constable of Kent. So what happened in RV Larsenair? In RV Larsenair, it can be remembered, right, that they accused, right, or Larsenair was actually refused permission to enter the United Kingdom, right? So looking at that, and he was actually brought to the UK by police, where he was found in the United Kingdom, which he was permitted from entering, right? And actually there was committed a crime. So he was actually charged with being found in the United Kingdom. It's a weird case. It's kind of I find it kind of stupid, right? But basically, Larsenair, right, was in the UK, and the police deported him, right? Well, he wasn't. Was he found in the UK? He was brought to the UK by police, right? So the thing is, no, right? He was refused. There has been a refusal of his permission to enter the United Kingdom, right? And the police, upon finding him, right, generally brought him to the United Kingdom to try him, right? And he was convicted with being found in the United Kingdom, but the police had brought him there, right? So we're looking at stuff like that. So it was one of those cases. Okay, so that was a general issue there for Larsenair. And we also have Windsor v Chief Constable Kent, right? So what happened in Windsor v CC of Kent? So Windsor was found drunk in the hospital stairway. The police took him out of the hospital and left him on the highway. Right? He was on the highway and the police came and arrested him for being drunk on the highway. So looking at those situations of complete stupidity. I mean, I know it's a law, but it just seems so stupid, right? He was drunk in the hospital. He was carried on a stretcher and left in the hospital, right? He was actually later seen slumped somewhere, right, in a chair corridor, right? And he was apprehended by the police and taken, right, to a car station outside the hospital. He was then charged for being convicted and found he was actually charged and convicted for being found drunk in the highway where the police had brought him. So looking at that, the surrounding substances, not substances, but circumstances, right, led to some amount of illegalities, right? So that what happened there. So RV Larsenair and Windsor versus Chief Constable Kent, right? Now we're looking at the elements of the mens rea. So we're gonna be looking at the elements of the mens rea now. All right. So that was in one entire hour speaking about the Actus Reus and all the elements of Actus Reus. That's crazy.